everybody. Welcome to our webinar on the Major Questions Doctrine following the Supreme Court's decision in Learning Resources. Today we'll be discussing primarily relevant Supreme Court precedents and how the doctrine has developed as opposed to policy ramifications and things like that. Today's webinar is brought to you by the Institute for Policy Integrity at NYU. We are a nonpartisan think tank that works in service of rational decision making. We focus a lot on environmental and energy law and policy, but we also do a lot of work on cross-cutting administrative law issues, such as the Major Questions Doctrine. My name is Bridget Pals. I'm an attorney here, and I'll be moderating today's discussion. Before we dive in, I have just a couple of quick housekeeping notes. So first off, what probably brings many of you here today, this presentation is eligible for CLE credit. You should have already received an email with the CLE affirmation form. If you did not receive that for any reason, we do also have a link to the form in the chat. You'll need to fill out that form and send it back to us. In order to do so, you will need a secret code word, which I will be providing later in this presentation. So keep an ear out for that. Second, I wanted to note that we are recording this webinar for later, so if there's anything you'd like to come back to at any point in time, you will be able to do that. And then last of all, please do use the question function to ask us questions. We've reserved some time at the end to get to audience questions, and we'd love to have some to respond to. Now on today's topic, as the title cued you in, today we'll be discussing the Major Questions Doctrine before and after the recent Supreme Court case, Learning Resources v. Trump. For those not familiar, that was the case where the Supreme Court determined President Trump lacked authority to issue tariffs under the International Emergency Economic Powers Act. Dodd Goodson, our executive director, is going to kick us off by discussing the history and development of the Major Questions Doctrine, and he's also going to highlight a couple of key active debates in the area. Next up, Max Zorinsky, our legal director, is going to discuss what the doctrine looks like post-Learning Resources. And then Kate Welty, one of our legal fellows, is going to talk about the Major Questions Doctrine in action through the EPA's recent repeal of its endangerment finding. For those not familiar, the endangerment finding was a finding that greenhouse gases threaten the public health and welfare, which allowed EPA to regulate greenhouse gases from car emissions and power plants, things like that. After that, I'll be summing up a couple of practice notes, and then we're going to meet back together for questions. Without any further ado, let me turn it over to Don.
Great. Thank you, Bridget. Just confirming that I think I should be visible. So I'll go and dive in. So thank you again, Bridget, and good afternoon, everyone. And thank you all for joining our webinar today on the Major Questions Doctrine. As Bridget noted, my name is Don Goodson. I am the Executive Director of the Institute for Policy Integrity here at NYU School of Law. And today I'll be covering the background on the Major Questions Doctrine. From its early seeds right up to the Supreme Court's decision in Biden versus Nebraska. And then my colleague, Max Zorinsky, will carry the story forward from there. Now, I tend to think of the doctrine's early development as unfolding in roughly three phases. You have the first period, which spans the earliest kind of ideas or seeds of the doctrine from about 1986, although that's debatable, all the way through around 2015. Then you have a period of intentional deployment and acceleration from around 2016 through 2022. And then finally, you get to the phase of the doctrine's full arrival with West Virginia versus EPA in 2022. And that period is continuing to go on to today. So I will, in my presentation, walk through these periods and then aim to leave you with some key ideas for thinking about the doctrine's importance. And as Bridget noted, I'm also going to talk about some of the lingering doctrinal questions. So starting with the early seeds of the doctrine's development, they were really ad hoc. While some may place the doctrine's origins earlier in time, I think they arguably begin in 1986 with an academic article from then Judge Breyer. He wrote this piece on agency deference, and in this article, he makes the seemingly common sense observation that when thinking about the types of questions on which an agency should get deference, it's more likely that Congress would have resolved major questions itself while leaving interstitial questions for the agency to resolve in the course of administering the relevant statute. And here's where we get that key phrase, major questions, from which the doctrine will later get its name. The next seed comes a few years later in 1994 in the case of MCI Telecommunications Corp. Versus AT&T. In this case, the Federal Communications Commission decided to use its authority to, quote, modify certain provisions of the Communications Act, which had required common carriers to file tariffs, to instead exempt all long-distance carriers except AT&T from filing tariffs. The court found that this was simply too fundamental a change in the statute's scheme of tariff filing to be found in a vague term like modify. Next, in 2000, we get FDA versus Brown and Williamson, which involved the FDA's decision to start regulating tobacco as a drug and cigarettes as drug delivery devices, despite decades of disclaiming the authority to do so. Here, the court found that this issue was simply too big of economic and political significance, that it's unlikely that Congress would have left it to the FDA to resolve on its own. Both cases also involved instances in which the court affirmatively chose not to apply Chevron deference and instead interpreted the relevant statutes itself. In the ensuing years, we get a string of cases from Whitman versus American Trucking Associations in 2001, to Gonzalez versus Oregon in 2006, Utility Air Resources Group, or UARG, versus EPA in 2014, and King versus Burwell, the Affordable Care Act case in 2015. Each of these cases builds on some of the ideas from MCI and Brown and Williamson, and to some degree, they also build on each other, but they don't share a consistent set of key features or even a consistent application. We get some key ideas, such as the observation in Whitman that Congress is unlikely to hide elephants in mouse holes, and in UARG that the court will greet with skepticism assertions of unheralded power in long extant statutes to regulate a significant portion of the economy. Notably, many of these cases involve situations in which Chevron deference would have been in play, but in which the early seeds of the doctrine provided a reason for the court not to defer to the agency and to instead interpret the statute for itself, even when the court actually reached the same conclusion as the agency, which happened in King versus Burwell. This is notable because an ongoing doctrinal question throughout this period, and arguably even now, is whether the major questions doctrine is really best viewed as just a carve-out from Chevron deference. I'm going to gloss over this question now, but we can return to it in Q&A if there's interest. The key point is that during this interim phase, during this early phase, even though certain ideas start to get repeated, there remains no clear understanding that a doctrine is emerging at this time, much less its specific contours. Things start to shift into the second phase during the first Trump administration, when we see a more intentional deployment of the doctrine, particularly by the administration itself. Most notably, the first Trump administration invoked the major questions doctrine as a justification for repealing the Obama administration's Clean Power Plan in the first Trump administration's own ACE rule. This is notable because the ACE rule gets litigated and, of course, years later ultimately results in West Virginia versus EPA. It's also notable because we see some similarities between how the doctrine was deployed during the first Trump administration's deregulatory initiatives and some similarities with how it is being used now by the current administration, particularly with respect to the endangerment finding, a topic my colleague Kate Welty will get to later in this webinar. But before we get to West Virginia, we see a trilogy of cases in which the doctrine is more intentionally deployed by litigants to challenge certain policies of the Biden administration. That's Alabama Association of Realtors versus the Department of Health and Human Services in 2021, Biden versus Missouri in 2022, and National Federation of Independent Business versus the Department of Labor also in 2022. Two of these result in the court striking down the challenged policies. That's Alabama Realtors and NFIB, arguably on major questions grounds, but without the court expressly saying that is what it is doing. But one notably results in the court upholding the challenged policy. That's Biden versus Missouri. This case is interesting because it's often overlooked in discussions of the major questions doctrine, but it is an early example of the court actually upholding a policy challenged on major questions grounds, despite its arguable political or economic significance. During this period, we also see litigants arguing in vague terms that the challenged policies trigger the doctrine because they are economically and politically significant, but we don't have a really good understanding of what that means. Litigants offer myriad indicia of significance, including things like cost, overall economic impact, number of affected persons, or the degree of public and political attention received. But the doctrine at this time very much has the feeling of a know it when you see it test, as then Judge Kavanaugh observed on the DC Circuit. And that takes us up to the third phase, the doctrine's full arrival in West Virginia versus EPA. And here we can go ahead and go to the next slide. Here, for the first time, the Supreme Court invokes the major questions doctrine by name in a majority opinion. And here, for the first time, we also see what begins to look like a clear, or at least clearer, framework. Carefully reviewing the court's analysis, one can see that it looks first at the triggers for the major questions doctrine, asking primarily two questions. First, is the asserted authority unheralded? Meaning, is it unlike anything the government actor has done before? And second, is it transformative? Meaning, would it fundamentally transform the nature of the actor's authority or the relevant scheme of regulation? Economic and political significance were alluded to in the court's analysis in West Virginia, but they were not dispositive or even really central to the court's analysis. And in terms of effects, we see the court state that if the doctrine is triggered, then the relevant government actor must point to clear congressional authorization for its actions. Now, this is an admittedly fuzzy phrase, but the key thing to observe here is that the Supreme Court in West Virginia did not actually require magic words. It's also equally important to note other things the court did not do in West Virginia. For example, in terms of triggers, the court did not rest on the myriad indicia of significance that litigants had urged the court to rely on in briefs filed before the court. And as I noted just a moment ago, it did not rest on significance alone. And in terms of effects, the court did not refer to the doctrine as a clear statement rule or some other similar substantive canon. Justice Gorsuch did in his concurring opinion, but only Justice Alito joined him. The following year, and here we can move to the next slide, we get Biden versus Nebraska. Here we see the court apply the same analysis it had applied in West Virginia, asking first whether the action was unheralded, then whether it was transformative, and then only after addressing those two questions, turning to whether it was of economic or political significance. This reiteration of the framework shows a real coalescing around the triggers for the doctrine. That said, one thing that's interesting about Biden versus Nebraska is that the court's major questions analysis comes after it had already applied ordinary tools of statutory interpretation to resolve the key questions at hand, with the major questions analysis merely serving as confirmation of what it had already concluded earlier in the opinion. Turning to the next slide, in Biden versus Nebraska, we also begin to see a clear divide among the conservative justices in the majority on the effect of the doctrine, or what happens when the doctrine applies. On one side, we have Justice Gorsuch, who tried repeatedly in his West Virginia concurring opinion to label the doctrine a clear statement rule, using the term at least 17 times. This label is important because a clear statement rule would potentially allow a court to depart from the best reading of the statute if it furthered some external norm, say a separation of powers, like avoiding a separation of powers problem. On the other side, we have Justice Barrett, who authors a concurring opinion in Nebraska, explaining that the doctrine is more like a linguistic canon that aids a court in finding, not departing from, the best reading of the statute. This position is perhaps unsurprising, given that Justice Barrett's scholarship before she joined the Supreme Court demonstrates that she is uneasy with substantive canons like clear statement rules because they don't sit well with her textualist impulses. Now, I think the best reading of both West Virginia and Nebraska is that the majority opinions more closely align with Justice Barrett than Justice Gorsuch, though I recognize there can be a difference of opinion on that question. All right, so we'll turn to the next slide, and I'll conclude with just some final thoughts. So after Biden versus Nebraska, we have a clearer understanding of the doctrine, both in terms of when it applies and also what happens when it applies. But we have a lingering debate on that second question, namely, what type of canon is it? That said, and as my colleague Max Speransky will cover in just a moment, there remained at this time enormous confusion in the lower courts, especially on these two central questions. When does the doctrine apply, and what happens when it does? The answers to these questions are enormously important to just how big of a deal the doctrine is. On triggers, the doctrine could apply in only a handful of cases, or a handful of only truly extraordinary cases that involve truly unheralded and transformative exercises of authority, or it could apply in a wide range of ordinary cases that have arguably large economic or political significance, however that is defined. On effects, the doctrine could be a substantive canon, much like a clear statement rule, that places a thumb on the scale against finding a delegation of authority. Or it could be merely a linguistic canon that serves as an aid in finding the best reading of the statute. Now, again, I think the court answers both questions pretty clearly in both West Virginia and Nebraska, but there admittedly remains a great deal of confusion in the lower courts at this time on these issues. And with that, I will hand things over to my colleague, Max Uransky.
Great. Thanks so much, Don. So talking more about the confusion in the lower courts. So after West Virginia, there was an explosion of references to the major questions doctrine in lower court opinions and in litigants' briefs. In the 4 years since the case has been decided, there have now been over 100 lower court decisions that have invoked the doctrine, and that's far more than before West Virginia, when the doctrine really only showed up here and there in a handful of cases. And lower courts have been quite fractured on how to apply the major questions doctrine, with really no singular unified approach emerging from them. Some courts have looked primarily or only at the economic or political significance of the action or the power being challenged. So they've simply said, this is very significant. Sometimes they pointed to various indicia of significance, like the economic impact of the action, the number of people affected, the number of comments on the regulatory docket, those types of indicia, and then applied the major questions doctrine purely on that basis. Some courts have pointed to Justice Gorsuch's concurrence in West Virginia to look primarily at economic significance. And they've also pointed to his concurrence to look at a hodgepodge of other factors, primarily involving significance as well. So in Justice Gorsuch's West Virginia concurrence, he said political significance alone can trigger the major questions doctrine. He said an intrusion on a traditional area of state authority, that can trigger the major questions doctrine. And he framed the doctrine really as a disjunctive test that can be met with really only one of these indicia of significance. Some lower courts have pointed to that. And as a result, some lower courts have applied the doctrine in real edge cases where you had large programs with large costs, looking at them on their own terms, but the costs were actually quite ordinary when looked at in the context of the program or prior government actions in the area. And then some lower courts have followed, or many lower courts, I should say, have followed the West Virginia test of looking at unheralded power, transformative power, and significance, and applying those as a conjunctive test where all the factors need to be met. As I said, this has not been uniform, and there's actually been a fair amount of inconsistency within courts from one case to the next. So, for instance, in the Fifth Circuit, we've seen all three versions of the major questions test, and all within a period of about 16 months after West Virginia was decided. And in terms of the effects of the doctrine, lower courts have expressed uncertainty over whether the doctrine is a linguistic canon or a substantive canon, pointing to the dueling concurrences from Justice Gorsuch and Justice Barrett. And a number of courts have openly said that this issue is unclear from the Supreme Court's cases and have effectively dodged the question and called for more clarity from the Supreme Court. And with such an amorphous test, what we've seen in many cases are outcome or results that appear at least to be outcome driven. So during the Biden administration, when we saw a real increase in the invocation of the major questions doctrine, judges who were appointed by Republicans frequently struck down executive actions based on the doctrine, and judges appointed by Democrats would often uphold executive actions, finding that either the doctrine wasn't triggered or was met in some other way. During the Trump administration, there's been a bit of a flip of this, although the invocation of the major questions doctrine has been much less frequent during the Trump administration, even though there has been a lot of litigation against the Trump administration and many of their actions have been struck down. There's actually been fairly little major questions case law now over the last 15 months. And as I said, on occasion, courts have struck down ordinary agency actions that bore few or no hallmarks of major questions cases, basically ordinary exercises of executive authority that were consistent with past agency practice. During the Biden administration, we would on occasion see such actions being struck down based purely on their significance alone, on a fairly undisciplined application of the major questions doctrine. So moving on to learning resources. So what was this case about? So as most people here probably know, in April of 2025, President Trump imposed global tariffs under the International Emergency Economic Powers Act. That act authorizes the president to regulate importation of any property in which any foreign country or national thereof has any interest by any person, so long as he finds that there's an unusual and extraordinary threat to the economy or to national security. And importantly, the ellipses there are doing quite a lot of work. Regulate is one of, I believe, 11 verbs in the statute. It's investigate, block, regulate, direct and compel, nullify, so forth. And importation is one of, I believe, 9 nouns. So, the statute on its face gives the president rather broad authority, so long as he declares that there's an unusual and extraordinary threat. And here the president claimed that the threat were the country's persistent trade deficits that have existed over decades. And importantly, under IEEPA, and this is by design in the statute, there's no process once the president declares the emergency and invokes the statute. There are no specific processes or findings that he must make. There's no fact finding that's necessary. And there are no limitations on the scope of the actions. So, if the president can issue a tariff for one good under IEEPA, presumably he could issue a tariff for all goods, so long as it's connected to the unusual and extraordinary threat. And importantly, the Administrative Procedure Act does not apply to presidential actions under IEEPA, because under the Administrative Procedure Act, the president is not captured as an agency subject to that statute. So that means that arbitrary and capricious review, which would ordinarily apply to agency actions that involve fact-finding, do not apply here. So the authority that the president was claiming was quite broad. And unsurprisingly, it was challenged in numerous federal district courts, although, as the Supreme Court clarified, the Court of International Trade had exclusive jurisdiction over the case. The plaintiffs made a series of arguments, and they invoked the major questions doctrine. And in invoking the doctrine, they pointed to a number of the factors that the Supreme Court has looked at before. So in terms of the history of the statute and arguing that this application is unprecedented, they pointed to the fact that IEEPA, which is from the 1970s, had never been used for tariffs in its 50-year history. Previously had been used for much more surgical actions like sanctions or asset freezes, like prohibiting transactions with the Taliban or restricting enriched uranium, things like that. There was a bit of an evolution in the parties' arguments. In some of the cases before the district court, some of the plaintiffs focused primarily on the economic and political significance of the president's tariffs, but as the case moved up, they focused much more on the unheralded and transformative nature of the action. And in terms of transformative, they argued that the president was transforming what was supposed to be a narrow emergency tool into basically a procedure that could override all of the trade statutes that Congress had laid out. And importantly, it's important to understand that the president does have fairly broad tariff authority that's explicitly granted in other statutes, but those authorities are cabined in terms of the process, the duration, the amount of the tariff, the fact finding that has to go into it. So there are a number of statutes that do provide for tariffs, but not in this kind of blanket and broad way that the president was asserting under IEEPA. The government opposed the application of the major questions doctrine. They said it should not apply in the foreign affairs context, where the Constitution grants the president some authority and we presume that Congress delegates very broadly, particularly when you have a statute like this one that's broadly worded. And they said even if the major questions doctrine does apply, that the text of IEPA is so broad that it provides the clear congressional authorization that we would look for if the statute were triggered. Interestingly, the government did not they did not rebut the argument that this application of IEPA was either unheralded or transformative, or that it had major economic and political significance. They said the statute doesn't apply kind of broadly to foreign affairs and to emergency statutes. And then they said, but even if it does, we have clear congressional authorization here. So, and then in the lower courts, we had an injunction in the Court of International Trade, which was upheld by the Federal Circuit. That case was known as VOS Elections versus Trump. Those rulings were stayed pending Supreme Court review. And the decisions were based on statutory grounds, with the major questions doctrine playing a very prominent role. And importantly, when the Federal Circuit discussed the major questions doctrine, it applied the three-part conjunctive West Virginia test of unheralded, transformative, and vast economic and political significance. So, you know, the major questions doctrine, of course, came up in the Supreme Court briefing quite extensively. A number of the briefs touched upon it. We filed an amicus brief in the case where we called for more doctrinal clarity consistent with the prior case law. So basically saying West Virginia and Nebraska together lay out a relatively clear test, but lower courts have not all gotten the message, and it's important for the Supreme Court to clarify what the test is and how it applies here. And as we explained, it should be a three-part conjunctive test. We said that all three parts of the test were met in this case, and that it's a linguistic canon, not a substantive canon. And we argue that there should be no carve-out for presidential actions or for delegated foreign affairs. Okay, so moving on, we got the Supreme Court's opinion in the case in late February, and the major questions doctrine was really the primary issue at play in the case. It was a 6-3 split. There are 6 justices in the majority that found that IEPA does not authorize tariffs. The 3 justices in dissent argued that IEPA does authorize tariffs. And there were 7 opinions in this case, at least 5 of which really went into some detail on the major questions doctrine, and arguably the other 2 touched upon it as well. The majority itself was fractured, so there were 5 opinions on the major questions doctrine, and actually none of them got a majority of the court. So you had a plurality opinion from Justice Roberts that was signed on to by Justice Gorsuch and Justice Barrett, and they argued that the major questions doctrine was triggered, and it was not met, so IEPA does not authorize tariffs. So what made them say that the major questions doctrine is triggered? Well, they walked through basically the same factors that they had looked at in West Virginia and Nebraska. So in terms of the unprecedented nature, they pointed to the fact that there had been 0 IEPA tariffs in the 50 years of the statute, and that tariffs had, during that time, been issued under other statutes. Looking at the transformative nature of the authority, they point to the fact that, you know, the president could unlock the full tariff power by a single unreviewable emergency declaration under the president's reading of IEPA, and they called this, you know, they said that these would be getting rid of significant procedural limitations in other tariff statutes, and all it would take to unlock that is the president's declaration of an emergency, which the government asserts is unreviewable. In terms of the economic and political significance, that largely spoke for itself. The court pointed to several economic estimates, including $4 trillion in revenue that the government was projecting over a decade. The major questions doctrine applies to emergency statutes, the majority found, and it applies to foreign affairs, at least when we are in an area that the Constitution gives the authority to Congress, not to the president. So the Congress has authority under the Constitution to tax, to regulate foreign commerce. So in that context, I said it makes sense to apply the major questions doctrine. And then the majority went on and found that there's not clear authorization in this case. They looked at dictionary definitions of the word regulate. They looked at neighboring words in the statute, finding that the president's broad reading would basically render all the other verbs in the statute redundant and unnecessary. They looked at other statutes, questioning whether regulate ever means tax. They looked at legislative history of IEPA under President Nixon and what Congress did or didn't consider about the power to tariff at that time. And they also looked at case law under IEPA and asked basically whether prior case law was consistent with its application for tariffs. And looking at all that, they basically found that there was nowhere near the clear congressional authorization that the major questions doctrine requires. Justice Kagan, joined by Justices Sotomayor and Jackson, wrote a concurrence where they agreed that IEPA does not authorize tariffs, but they said that this can be done through ordinary tools of statutory or interpretation, and there's no need for the major questions doctrine in this or potentially any other case. And Justice Kagan said that statutory interpretation in all cases should mean examining the language, looking at the broader statutory scheme, and applying some common sense about how Congress typically delegates. And if you look at statutes in that way in all cases, there's really no need for some special major questions doctrine that would apply in particular cases. Justices Gorsuch and Barrett reprised their dueling concurrences on the effect of the doctrine. Justice Gorsuch argued it's a substantive canon. Justice Barrett argued that it's a linguistic canon. And they both basically doubled down on their earlier positions. Although interestingly, Justice Gorsuch's concurrence does not take issue with the doctrine's triggers. He doesn't claim the doctrine should require anything less than unheralded, transformative, and vastly significant power. So that seems to be a bit of a backtrack from his West Virginia concurrence. And then in dissent, Justice Kavanaugh, writing for himself, Justices Thomas and Alito, he argued that IEPA does authorize tariffs. But he did find that the major questions doctrine, well, sorry, let me back up. He said that the major questions doctrine normally should not apply to foreign affairs, where Congress deliberately gives the president flexibility to have a broad discretion in the foreign affairs context. But he said that even if the major questions doctrine applies, there is clear congressional authorization here, and he pointed to the very broad text of IEPA. He pointed to some relevant legislative history and some analogous case law. And he said if you put those all together, you get to clear congressional authorization. And Justice Kavanaugh, just like the majority opinion, said that the major questions doctrine is not a magic words test. It could look at text, history, precedent, all of them count in considering clear authorization. So moving on, I'll summarize with some key takeaways of this case and what it means for the major questions doctrine going forward. So number one, the major questions doctrine is here to stay. There was some debate over the status of the major questions doctrine following Loper-Bright, which ended Chevron deference. And as Don mentioned earlier, the major questions doctrine began as a carve-out to Chevron deference. So there's a question of whether it would remain after Chevron deference was no longer applicable. And the Supreme Court didn't address that question directly, but the answer to them is clearly that it does. 6 justices still endorse the doctrine. 2, the doctrine is primarily about regulatory transformation, not economic cost or political salience. As Don said, this is consistent with the court's prior applications of the doctrine in West Virginia and Nebraska. But in case it wasn't clear from those cases, I think it's even more abundantly clear after learning resources. We're here once again, economic cost and political salience are much more secondary factors that on their own are insufficient. And as I said, even Justice Gorsuch signs on to this, even though his concurrence in West Virginia raised some concerns about that. Number 3, when the doctrine applies, it requires clear congressional authorization that can be satisfied using all interpretive tools. So I think 8 of the 9 justices agree with this statement. They say that it's not a magic words test, that ordinary tools of interpretation can apply. And importantly, the main plurality opinion from Justice Roberts, he quotes Justice Barrett's Nebraska concurrence numerous times, strongly signaling that he sides with Justice Barrett on the doctrine's status as a linguistic canon. And Justice Kavanaugh, his dissent agrees on this method too. It just reaches a different result, but it too argues that the major questions doctrine can be satisfied through ordinary tools, looking at context, purpose, and history. And finally, the doctrine applies to delegated presidential actions, including those involving foreign affairs. And on this, the vote was 6-3. And as the majority pointed out, and Justice Gorsuch, prior major questions cases had raised some of these issues before. So Nebraska concerned an emergency provision. West Virginia itself involved some foreign affairs issues, and this is not a new issue here. So I'll end there, and I'll turn it over to my colleague Kate. We'll talk about how the Trump administration is using major questions doctrine.
Hi, everyone. Thank you, Max. My name is Kate Welty. I'm a legal fellow here at Policy Integrity. Just quickly before I start, I want to plug our Q&A function. There's a Q&A function in the Zoom chat. Please submit your questions. We'll have time for questions at the end, and we'd love to see them. So Don and Max have given a great background into how the major questions doctrine has developed and how courts, including the Supreme Court, have explained its contours. I'm going to talk a little bit about how we've seen the current administration use the doctrine, and specifically how we've seen the administration use the doctrine in its repeal of the endangerment finding. So just quick to start, some background on what I mean by the endangerment finding. Under Section 202 of the Clean Air Act, EPA must regulate those emissions of air pollutants from new motor vehicles if it finds they cause or contribute to air pollution, which may reasonably be anticipated to endanger public health or welfare. And this sets up a two-part structure for EPA. It must make a scientific inquiry into whether emissions from motor vehicles contribute to an air pollution danger, and if it finds they do, it must regulate those emissions. So in 2003, environmental advocates petitioned EPA to regulate greenhouse gas emissions from cars. EPA denied the petition. It claimed it lacked the statutory authority to do so. That denial was eventually appealed up to the Supreme Court. And in the 2007 landmark Supreme Court case, Massachusetts v. EPA, the court found that greenhouse gas emissions do fit within the statute's definition of air pollutant, and said that EPA must regulate those emissions if it finds they contribute to dangerous air pollution. 2 years later, in 2009, EPA issued its endangerment finding, the finding that greenhouse gas emissions from cars contribute to dangerous air pollution. On this basis, they built greenhouse gas vehicle emission standards for light, medium, and heavy-duty vehicles. It has updated those standards repeatedly over the last 15 years, most recently under the Biden administration in 2024. So why is the endangerment finding in the news now? In February of this year, EPA finalized a rule repealing the endangerment finding alongside all of the greenhouse gas vehicle emission standards it had engendered. And among its myriad reasons for revoking the finding, EPA invoked the major questions doctrine. It claimed that the doctrine applied and that the agency lacked the clear authority to regulate these emissions. And there's three main arguments EPA makes that I want to highlight. First, EPA says that regulating these emissions is economically and politically significant. It cites the compliance costs associated with these emission standards and paints it as a big question of policy. It says that pre-2009, so before EPA made its endangerment finding, Section 202 had never been used to address global air pollutants. EPA argues that the statute was meant to apply only to local or regional air pollution, not those types of pollutants with global, more attenuated impacts. And three, EPA says that regulating greenhouse gases required EPA to broaden the scope of its authority, to use the Clean Air Act in a way that it never had before. And on this basis, EPA determined the doctrine applied. It looked to the statute. It concluded that it had no clear authorization to regulate. So moving on, I want to evaluate those arguments. And in particular, I want to look at two main claims that EPA is making here. So first, was regulating greenhouse gas emissions at the time really unheralded? In short, no. EPA is routinely considered non-local and non-exposure-based effects on health and welfare when regulating under Section 202 and under related Clean Air Act provisions. And important to understanding some of the regulatory history here, the endangerment framework that we see in Section 202 is actually a framework that Congress used throughout the Clean Air Act. So under portions of the Clean Air Act where EPA has authority to regulate stationary sources or non-road vehicles, we see this endangerment language, and we see from the legislative history that EPA was intended to interpret this language similarly. So regulatory examples from other parts of the Clean Air Act are actually instructive in understanding how EPA has used this authority. And one particularly helpful example here is actually EPA's regulation of methane from its 1996 regulation of emissions from municipal solid waste landfills. Under that rule, EPA regulated methane and cited its contribution to global greenhouse gas emissions and resulting climate change impacts as part of its regulatory rationale for regulating. It painted these emission standards as part of its climate action plan. And this was 13 years before the 2009 endangerment finding. Similarly, in the late 1980s regulation of chlorofluorocarbons, which was done under a provision of the Clean Air Act meant to regulate stratospheric ozone problems that had similar language requiring endangerment as under 202, the agency noted that these pollutants were global in nature. They were widely dispersed, and so emissions from one country might affect public health and welfare in another. And even under Section 202 specifically, we see a long regulatory history of EPA regulating more attenuated indirect impacts. So, for example, we see EPA citing things like the effects of acid rain on property values or on economic impacts of fish kills associated with excess nitrogen in surface waters. And these are kind of attenuated indirect impacts that look something more like the effects of climate change than these particularized direct health impacts of things like particulate matter, for example. And these examples confirm that EPA in 2009 was not acting in an unprecedented or unheralded way. It was continuing its regulatory history of regulating these types of impacts. Moving on to our next question, was regulating greenhouse gases really transformative? Oh, sorry, still the same slide, Matt. And in looking at whether it was transformative, it's actually important that we look first at the statutory text. So as I've mentioned, Section 202 covered those pollutants that endanger public health and welfare. Now, what it means to impact public health isn't defined in the statute, but impacts on public welfare are. And the definition specifically mentions that EPA should consider impacts on climate. Because the welfare analysis must account for climate impacts, the provision clearly covers those pollutants which affect the climate. It's also helpful to look at congressional action and legislative history. So in the legislative history from the 1970 Clean Air Act amendments, which is when this endangerment framework became pervasive throughout the act, we see that Congress was aware of and concerned about climate change when it passed those amendments. It knew certain air pollutants could affect global climate, and it was concerned and wanted to regulate those impacts. Similarly, more recently, we see recent congressional action, like repeated appropriations for money to administer greenhouse gas vehicle emission standards, or a 2021 Congressional Review Act resolution, which directly provided for greenhouse gas standards under Section 111. We don't see silence. We see Congress specifically going out there and providing for this type of regulation. And so EPA wasn't transforming its authority when it regulated greenhouse gases. It was really using it as designed. So one more thing I want to mention. At the top of my presentation, I mentioned a case called Massachusetts v. EPA. So if we assume that greenhouse gas regulation really was unheralded and it really was transformative, if the major questions doctrine applies, then the agency just needs to point to clear congressional authorization for it to regulate. Matt, could we go to the next slide? And under Massachusetts, the court held it was unambiguous that Section 202 covered greenhouse gas emissions. It looked at the capaciousness of the Clean Air Act's definition of air pollutant and specifically considered whether under Section 202, EPA had the statutory authority to regulate these emissions. The court's holding was squarely about Section 202. And that interpretation really provides the clear authorization the major question doctrine requires. And if this question were to reach the court again, as we suspect it may in the endangerment litigation, the court should be bound by the legal doctrine requiring courts to follow established precedent. That's stare decisis, or in this case, we say statutory stare decisis, which refers to stare decisis for statutory interpretation rulings. And statutory stare decisis is actually a superpowered form of stare decisis. It holds even after a change in interpretive methodology, And the theory is that when the court interprets a statute, if the Congress disagrees, it could correct any statutory misreading in the future. But nearly 20 years after Massachusetts, Congress has done nothing to disturb this finding. And so there's really no reason that this should be overcome. And finally, it's important to note that in Massachusetts, the court almost did this major questions analysis that EPA now tries to do in its repeal. So Don mentioned earlier in his presentation that there's a foundational case to the major questions doctrine called FDA versus Brown and Williamson. And in that case, the court found that the Food and Drug Administration lacked authority to regulate tobacco under the Food, Drug, and Cosmetic Act. It said this was an unprecedented sort of regulation. Congress had repeatedly signaled that FDA lacked this authority, and it was an economically and politically significant question. In Massachusetts, the court considered the application of Brown and Williamson directly, and its analysis of the case actually tracked a lot of the modern major questions doctrine framework that Don and Max explained earlier. The court asked, was EPA's regulation of greenhouse gas emissions consistent with its prior statutory understanding? So was it transformative? Was it consistent with EPA's prior regulatory history? Was it unheralded? And the court found nothing counterintuitive about EPA exercising this authority. So the court has effectively already run the MQD test on this question, and EPA lost. And putting all those pieces together, we see that the endangerment finding is a pretty poor vehicle for applying the major questions doctrine. Regulating greenhouse gases was neither unheralded nor transformative in 2009. This is confirmed by Massachusetts. And even if the doctrine applied, the court already found it's unambiguous that the statute applies to these pollutants. And this is even further confirmed and backed up by statutory stare decisis principles. I'm going to pass it back to Bridget now, who's going to talk a little bit about some key practice notes for practitioners who are assessing the applicability of the doctrine.
Thank you, Kate. So really quickly, I'm just going to cover a couple of key practice notes before we move on to Q&A. So there are two primary ways that we would expect the major questions doctrine to arise when we're assessing federal actions. So the first is the government's asserting a new power, such as the IEEPA tariffs, and that new power seems, unheralded, transformative, of great economic and political significance, et cetera. And the other way it may come up is if the government is actually rolling back existing regulations, but is claiming that it lacks the authority that it previously asserted in order to create that regulation in the first place. And so an example of this is, as Kate just discussed, the endangerment repeal. So if you have one of these types of actions and you want to assess whether or not the major questions doctrine applies, as we've discussed throughout this presentation, we'll look to whether it's unheralded, transformative, of great economic and political significance, and we do need to consider all three prongs. So in practice, what does that mean? So for unheralded and transformative, those two prongs, we're going to want to look at regulatory antecedents. So this means cozying up with the Code of Federal Regulations and the Federal Register and spending some quality time understanding what has the agency done before, what relevant rules has the agency promulgated, does the agency have guidance explaining the scope of their authority as they understand it. That type of evidence can be particularly useful, especially if it spans back over a long period of time. And then as we look at the breadth of the authority asserted, we'll also be relying on legislative design, agency expertise, and then prior understandings of agency authority. So again, those past agency guidance documents, prior regulations, what an agency has written in prior preambles in the Federal Register, all of those things are going to be really useful. And then when looking at economic and political significance, we'll want to examine the scope of the authority asserted. So what is the scope? What's the scale? What's the economic impact? In other words, how many people are affected by the regulation, or how large of an economic impact in dollars will it have, things like that. Now we are going to turn to Q&A, although we are going to have time only to very quickly address a few questions. And the first question I'm going to ask is going to go to you, Dawn. And we received a question from the audience asking if we could walk through the distinction between transformative and significance. And I'm going to take moderator's privilege and expand that to the distinction between unheralded and transformative, as well as the distinction between transformative and significance.
Great. Thank you, Bridget. And thank you for the question from the audience. So admittedly, the various components of the doctrine do bleed together. And I think this is one of the most common questions that people pose is what are the differences between the different prongs? And then also clear congressional authorization, which starts to feed into it as well. So the way that I like to think about it is the first question is really historical, and it's informed by the Chief Justice's observation, West Virginia versus EPA, where he says basically, if a government actor actually has this authority, they're incentivized to use it. And so you'll be skeptical if this authority has been sitting around for a very long time and not exercised because of this tendency to exercise authority if you have it. And in EPA, for example, he notes that according to his reading and the majority opinion, EPA's past regulations under Section 111 had been focused on kind of more, source-specific measures that would reduce pollution by causing the regulated source to operate more cleanly, versus the purposeful generation shifting of the Clean Power Plan was looking more outside to other sources as a means of controlling pollution. So that's the first way that the court thinks about unheralded and this break with past practice. And then in terms of transformative, the question is thinking about the nature of the regulatory scheme or the actor at hand. And this is where I think Kate and others noted, you think about expertise. Is this like the type of thing you would expect Congress to give to this particular agency? If not, that seems to suggest that it's transforming the role of this particular actor. So in Gonzalez versus Oregon, it was a question about a medical judgment being made by the Attorney General rather than somebody else who actually had medical judgment. In West Virginia versus EPA, it was EPA taking what those courts saw as more authority over the energy sector and making determinations about transmission and the like that would actually rest with someone else. And as Max touched on as well, you see in IEPA, the tariffs that the current administration imposed were the first time ever that tariffs were imposed under IEPA, so satisfying that unheralded question. And in addition, it would give the president effectively a blank check, the interpretation that he adopted, rather than the relatively finely tuned scheme of tariffs that existed throughout the US code. So that's kind of the key way I think about those two different factors. And then with respect to significance, the court has looked more clearly at things like in Alabama Realtors, the kind of billion-dollar proxy of the effects. Same thing for Biden versus Nebraska, also the tariffs litigation. And then the political significance is often the court looking at, intense debate in Congress, often in terms of proposing particular types of legislation that might look a lot like what the relevant actor is doing here. And all of those together are what raise that skepticism filter that Justice Barrett talks about, directing the court to look to a broader range of context to understand if this is in fact the type of congressional authorization that was given.
Great, thank you, Don. Max, the next question I'm going to send over to you. And so the question is, if the major questions doctrine is a linguistic canon, does it apply to interpretation of the Constitution?
I'll take that one really quickly in light of the time. So the major questions doctrine has been used by the Supreme Court only as a doctrine of statutory interpretation, not of constitutional interpretation. Of course, the court does have some vaguely analogous doctrines in the constitutional context where they also look at history and original purpose, but they've never talked about the major questions doctrine in the constitutional sphere.
Great, thanks, Max. And then I'm actually going to shoot another one over to you, which is the major questions doctrine an even-handed doctrine, or would you say it's more inherently deregulatory?
Yeah, that's a great question. I mean, some of the earlier cases on the major questions doctrine do invoke it in a deregulatory context. So MCI is a deregulatory case. Whitman versus American Trucking, the court used the major questions doctrine to rebut an interpretation of the Clean Air Act that was seen by most people as a deregulatory interpretation of the statute. So it is possible. That said, in the more recent cases, the Supreme Court has defined the doctrines applying to a transformative expansion of authority, not just in transformative use of authority. So, I think the current Supreme Court might be somewhat skeptical of using the doctrine in a deregulatory context. That said, I mean, I think, a lot of the inquiries that you look at in the major questions doctrine, looking at congressional purpose, legislative design, regulatory history, these are the same types of considerations that one could look at in an ordinary statutory interpretation context. And in fact, Loper-Bright points to some of the same considerations, particularly in terms of regulatory history. So, I think you could look at some of the same factors, but I would be somewhat hesitant to invoke the major questions doctrine by name in a deregulatory context.
Thanks, Max. I think we have time for one more quick question, and then we'll call it because we're already running a little bit over. But Kate, I was wondering if you could talk a little bit about how this current administration has used the major questions doctrine as a deregulatory rule more broadly, as a deregulatory tool, sorry, not rule.
Sure, I can also go quickly here. So I think at the beginning of this administration, we thought we might see it used quite a bit. So in April 2025, President Trump issued a memorandum calling on agencies to repeal actions they believed were inconsistent with 10 recent Supreme Court cases. And on that list was West Virginia. That was followed by a memo from the Office of Management and Budget, which instructed agencies to assess whether their regulations implicated the major questions doctrine. Following those directives, we saw major questions come up in a few deregulatory actions within the last year and a half. That includes an EPA's proposed repeal of its greenhouse gas standards for the power sector, its rule limiting state water quality certifications under Section 401 of the Clean Water Act, and in a proposed OSHA rule that would narrow the agency's authority under the General Duty Clause. But of the examples where we've seen the major questions doctrine come up, the repeal of the endangerment finding definitely relies the most heavily on the doctrine. And overall, we actually haven't seen the administration use the doctrine as their primary tool for deregulation, at least not to the extent as I think was indicated by those early memos.
Wonderful. Thank you so much, Kate. And thank you, everybody, for joining us today. Thanks to our panelists, Max, Don, and Kate, and also to everybody else involved in making this webinar happen, including Matt, who is currently running this entire show. Again, please do turn in those CLE affirmation forms if you would like CLE credit. And thank you all for joining.